Geneva Convention and Protocol. We are your presenters for this topic, Satriani De Guzman, Jona Calibuso, and Queenie Purisima, in partial compliance with the subject Public International Law. The Geneva Convention and Protocol is a body of public international law, also known as the humanitarian law of armed conflict. The history of the creation of the Geneva Convention traces back in the 1800s, where a Swiss businessman named Henry Duttant went to visit wounded soldiers after the Battle of Solferino in 1859. Duttant was shocked by the lack of facilities, personnel, and medical aid available to help the soldiers. And because of this horrific experience, he was led to write a book called A Memory of Solferino, wherein he proposed the following solutions to the dilemma of lack of medical assistance to these wounded soldiers. Number 1, Duttant proposed a permanent relief agency for humanitarian aid in times of war, which is deployed during war to heal those who are afflicted and wounded. And today, because of this proposal, which was subsequently accepted by the international community, led to the creation of what we call now the International Committee of the Red Cross, or the ICRC. And lastly, and the most important, Duttant proposed a government treaty recognizing the neutrality of the agency and allowing it to provide aid in a war zone. This proposal led to the establishment of the Geneva Convention. The said treaty, in light of the circumstances surrounding its creation, aims to protect the wounded and infirm soldiers and medical personnel who are not taking active part in hostility against a party, ensure humane treatment to them without discrimination founded on race, color, sex, religion or faith, and birth or wealth, prohibit torture, assaults upon personal dignity, and execution without judgment, and grant them the right to proper medical treatment and care. The Geneva Conventions are 4 treaties and 3 additional protocols that establish international legal standards for humanitarian treatment in war. But this presentation, we will discuss and focus only in the first convention, the amelioration of the condition of the wounded and sick in armed forces in the field, which was signed on August 22 of 1864 at the Alhambra Room of Geneva's Hotel de Ville. Now, the specific convention, in comparison with the other 3 conventions, highlights the amelioration of the effects of war on wounded or sick soldiers who are particularly found on land by providing them with medical assistance and treatment. The purposes and principles of this convention are the following. Number 1, to give medical assistance and treatment to wounded and sick soldiers who are not or no longer taking part in hostilities. Second, to limit the brutality of war. Third, to provide immunity from capture and destruction of all establishment for the treatment of wounded and sick soldiers and their personnel. Fourth, to give impartial reception and treatment of all combatants. Fifth, to provide protection of civilians, providing aid to the wounded and sick. And lastly, to recognize the Red Cross symbol as a means of identifying persons and equipment covered by the agreement. Now we shall proceed to the pertinent provisions of the first convention. Among the provisions of the first convention that the presenters view as necessary to highlight in our discussion is Article 2, which provides when the convention is applicable. Now, Article 2 provides that the first convention shall apply To all cases of declared war or of any other armed conflict which may arise between two or more of the high contracting parties, even if the state of war is not recognized by one of them, and all cases of partial or total occupation of the territory of a high contracting party, even if the said occupation meets with no armed resistance. Furthermore, Article 2 also provides that this convention applies to the states or powers in conflict, and although one of the powers in conflict may not be a party to the present convention, the powers who are parties thereto shall remain bound by it in their mutual relations. Now, Article 3, Number 2 gave the parties in conflict the duty to collect and care for the wounded and sick. Now that means the countries at war are under international obligation to still look for the well-being of those who are victims as a result of the war or the armed conflict, regardless whether they are enemies or not, and to provide them with medical assistance. And in relation to this article, we can see in Article 9 that notwithstanding that the primary givers of the medical treatment are the parties in conflict, the Convention allows other humanitarian organizations, such as the International Committee of the Red Cross, to undertake other humanitarian activities for them. So here we can find the interplay of other humanitarian organizations that may not belong to the states in conflict but still are willing to lend a hand to help those who are wounded and sick. And to continue, Article 13 enumerates the categories of persons to be protected by this convention, or in other words, the members of the armed forces on the field who are wounded and sick during a declared war or armed conflict. And for the sake of time, I would like you to visit the link provided in this slide for you to know and read the enumerations provided in Article 13 with respect to the persons covered by this convention. And so to continue, one of the pertinent provisions we can find in the first convention is Article 12, which set guidelines for the countries in conflict as to how these wounded and sick should be protected and cared for. Article 12 provides that these wounded and sick shall be respected and protected in all circumstances, treated humanely and cared for by the party to the conflict in whose power they may be, without any adverse distinction founded on sex, race, nationality, religion, political opinions, or any other similar criteria. They shall not willfully be left without medical assistance and care, nor shall conditions exposing them to contagion or infection be created. Also, women shall be treated with all consideration due to their sex. And lastly, the provision provides that the party to the conflict which is compelled to abandon wounded or sick to the enemy shall, as far as military considerations permit, leave with them a part of its medical personnel and material to assist in their case. And the last and important provision of the first convention is Article 47. Article 47 admonishes the high contracting parties to undertake in time of peace as in time of war the dissemination of the text of this convention as widely as possible in their respective countries, and to include the study of this convention in their programs of military and, if possible, civil instruction, so that the principles provided thereof may become known to the entire population, in particular to the armed fighting forces, the medical personnel, and the job lanes.
Now we go deeper to better understand the relationship of the Geneva Convention and Protocols to the international community. Currently, there are 196 signatories in the said convention, including the Philippines, with 12 original signatories, While Protocol 1 is ratified by 174 nations, Protocol 2 is ratified by 169 nations, and Protocol 3 is ratified by 78 nations. This map is an overview of which countries are signatories of the Geneva Convention and what countries ratified its protocols. As to the 12 original signatories, this includes the Swiss Confederation, Grand Duchy of Baden, Kingdom of Belgium, Kingdom of Denmark, Kingdom of Spain, the French Empire, the Grand Duchy of Hesse, Kingdom of Italy, Kingdom of the Netherlands, Kingdom of Portugal and the Algarve, Kingdom of Prussia, and the Kingdom of Württemberg. Philippines and the First Geneva Convention. The Philippines signed the First Geneva Convention on August 12, 1949 and ratified the same on June 10, 1952. Now, how significant is the said convention to the Philippines? The 1949 Geneva Convention, being the most universally accepted international humanitarian law treaty in the world, has brought great impact towards Philippines in acceding to international laws and in enacting legislations that would strengthen the implementation of IHL in the country. Because the said conventions reflects more than just a law, but it serves as the universal values and rules of ethical behavior in times of war and securing a minimum standard of treatment for all persons under all circumstances for the purpose of preserving humanity in the midst of horror. On the basis of Section 2, Article 2 of the Constitution, the Philippines renounces war as an instrument of national policy and adopts the generally accepted principles of international law as part of the law of the land. As such, the Geneva Convention should also be reflected in the Philippine laws and should actually be enforced therein. To strengthen its acquiescence to the Geneva Convention, the Philippines has incorporated many of the obligations of IHL into domestic laws. This includes Republic Act No. 9851, or the Philippine Act on Crimes Against IHL, Genocide, and Other Crimes Against Humanity, RA 10530, an act defining the use and protection of the Red Cross, Red Crescent, and Red Crystal emblems and providing penalties for violations, RA 11188, the Special Protection of Children in Situations of Armed Conflict Act, or the CSAC Law, RA number 9344, the Juvenile Justice and Welfare Act of 2006, and an administrative circular by the Supreme Court, AM number 18725. What is RA 9851? This law is enacted on December 11, 2009 and came into effect in 2010. This law defines war crimes, crimes against humanity, and genocide as being criminal. It clarifies the IHL by identifying particular offenses such as attack on civilians or medical staffs and establishing appropriate punishments and for holding both parties to the conflict responsible for violations of IHL. Moreover, this law covers both international armed conflicts, or the IAC, and non-international armed conflict, or the NIAC, whether the same was committed by state or non-state armed groups. Currently, there has only been one case that has been successfully prosecuted under this act, the case of Marawi Siege, which involves a case of sexual slavery, where a Maute group member was found guilty of violation of the IHL Act after he made a minor his sexual slave and repeatedly raped her during the latter's 5 months in capacity. But what is RA 10530? This is an act defining the use and protection of the Red Cross, Red Crescent, and Red Crystal emblems and providing penalties for its violations. This came into effect on June 2013 and provides guidelines in the use of the protective emblems, which is the Red Cross, the Red Crescent, and the Red Crystal, in times of armed conflicts, and ensures that only those authorized are using these protective emblems and that protected structures, transportation, and personnel are uniformly marked and identified. Thus, any misuse of the emblem shall be a violation of the said act. Under this law, AFP medical personnel can use the emblem in both peacetime and times of armed conflict to identify its medical personnel, units, and transports on the ground, sea, and air. And under such conditions, the AFP medical personnel shall wear armlets and carry identity cards displaying the Red Cross emblem. The said act further afforded AFP religious personnel the same protection and ensured that they are identified in the same way as the medical personnel. This is further strengthened by its 2018 implementing rules and regulations, which clearly indicated that the Red Cross emblem will be used in the Philippines and required the Department of National Defense and Department of Health to issue specific regulations detailing use of the Red Cross emblem for the military, police, and hospitals, whether private or public, for their personal structures and transports. RA 11188, or the Special Protection of Children in Situations of Armed Conflict Act, or the CSAC law. This is signed in January 2019 and provides special protection to children in situations of armed conflict from all forms of abuse, violence, neglect, cruelty, discrimination, and other conditions prejudicial to their development, taking into consideration their gender, cultural, ethnic, and religious background. The law also clearly identifies that it is the policy of the state to take all feasible measures to prevent the recruitment and use of children in armed conflict, and continue to recognize its primary role in providing effective protection and relief to all children in situations of armed conflict. The state acknowledges its responsibility to end impunity and to prosecute those responsible, especially for grave child rights violations in armed conflicts. This law also removed the criminal liability of minors who have committed grave child rights abuse by virtue of Sections 28 and 31 of the law, which provides that criminal cases against children involved in armed conflict shall immediately be dismissed, and thereafter the child shall be referred to the local social welfare and development office. However, an exception to this rule was stated under the Rule 19 of its implementing rules and regulations. Thus, criminal responsibility can only be considered for children involved in armed conflict who committed grave child rights violations under RA 11188 Section 9, and in such cases, the provisions of RA 9344 or the Juvenile Justice and Welfare Act as amended shall apply. Hence, only those children who were indirectly involved and children affected by armed conflict should not be held criminally liable under the CSAC law. So what is the Juvenile Justice and Welfare Act of 2006? This focuses particularly on children who are involved in armed conflict and have committed acts that will make them criminally liable under local laws. Although not a legislative act, the Supreme Court also took part in taking cognizance of the Geneva Conventions and Protocols by issuing a circular AM number 18725 in August 2018, designating IHL courts all over the country, where 11 IHL regional trial courts were designated as IHL courts, which are tasked to hear, try, and decide cases involving crimes punishable under the IHL Act committed in their territorial jurisdiction. The designation of IHL courts will facilitate the proper identification of judges, prosecutors, and public attorneys who should be given specialized trainings in IHL.
Impact of the treaty to the community. Known as a humanitarian law of armed conflicts, the Geneva Conventions and their additional protocols, as a body of public international law, provide minimum protections, humane treatment standards, and fundamental guarantees of respect to people who become victims of armed conflicts. It has impact on the community, on the treatment of civilians, prisoners of wars, and soldiers who have been declared outside the fight or otherwise unable to fight. But there are criticisms about this treaty. Some critics argue that the conventions are nearing the end of their useful lives and they are no longer appropriate for modern wars. But the proponents argue that the laws are still relevant and that the conventions, along with their additional protocols, remain to provide the best available framework for safeguarding civilians and non-combatants. Let me cite the current or significant news articles about the treaty. On August 13, 2019, that addressed peace and security in commemorating the 70th anniversary of the Landmark Geneva Conventions, the President of the United Nations Security Council hailed the significant body of law, describing it as playing a vital role in limiting brutality of armed conflicts. The greatest challenge to protecting human life in modern conflict is observance and respect for the existing rules by the armed forces and non-state armed groups. If these existing rules were followed, much of the human suffering in the contemporary armed conflicts would not occur. Poland's top diplomat also pointed to new threats that demand practices and policy consistent with international humanitarian law. As to Poland, artificial intelligence and autonomous weapon systems such as military robots and cyber weapons reduce the role and control of human factors during wartime. Moreover, the general rules of international humanitarian law prohibiting indiscriminate and inhumane weapons are now being violated. According to Mr. Azekutowicz, two international humanitarian law principles under the Geneva Conventions deserve a particular attention. These are the obligation to protect civilians, prisoners of war, the wounded and shipwrecked, as well as limitations on the rights of the parties to an armed conflict on how they conduct operations and on their choice of weapons. Conventions show what is possible. In this article, Peter Maurer, president of the International Committee of the Red Cross, maintained that the Geneva Conventions represent one of the greatest achievements of interstate cooperation and symbolize our enduring and common humanity. The conventions show us what is possible when states take collective and individual action to uphold the law and humanitarian principles. Every single day, international humanitarian law is at work, saving lives and protecting women, men, and children in conflicts. The impacts of international humanitarian law are also shown through acts of restraint when horrors are not inflicted. Civilian areas are spared from direct shelling. Medical workers are able to freely operate without threat or targeting. Continued violations do not mean the law is inadequate, but rather that efforts to ensure respect are inadequate. Moral flagged that we can and must do more. The world must not forget the Geneva Conventions represent a line of our common humanity and they shield us from our own barbarity. In the article of Geneva Conventions at 70, more enforcement needed. In 2019, 7 decades after the adoption of the Geneva Conventions, the treaties that contain the most important rules limit the barbarity of war, according to the International Committee of the Red Cross, don't appear to be limiting much of anything. In the 8 years of serious brutal civil war, there has been deliberately targeting civilian and civil institutions in areas held by the armed opposition, said Kenneth Roth, Executive Director of Human Rights Watch, calling it a blatant affront to the Geneva Conventions. In Yemen, the Southern Coalition has been repeatedly bombing civilian targets, hitting funerals, markets, mosques, and even a school bus. It is characterized by Amnesty International in May as extrajudicial executions, arbitrary arrests, torture, and other ill treatment and enforced disappearances is in essence ethnic cleansing. And these all events are serious breaches of international humanitarian law. Helen Durham, a former human rights lawyer and director of humanitarian law and policy at the International Committee of the Red Cross, agreed that her organization regularly sees violations of the conventions in the world's most dangerous place. But just because the law is broken doesn't make it less relevant. There are many cases where the laws of war actually make a huge difference and actually do provide dignity and humanity in war. Protection from the horrors of the war. The Geneva Conventions, adopted in August 12, 1949, aim to protect people not involved in conflict, like civilians, medics, prisoners of war, and soldiers who can no longer fight. The conventions have been ratified by 196 countries, including UN member states. And over the decades, said Durham, the conventions have been supplemented by a vast expansion and updating of specific treaties that relate to weapons with international agreements banning anti-personnel landmines, chemical weapons, and cluster bombs, among others. and they have said that new challenges like cyber warfare, autonomous weapons, and artificial intelligence, as well as calls to consider the environmental damage of war, will increasingly play a role in future developments.